Having covered international legal personality, so subjecthood, as well as the question of states coming into being, so statehood, I now want to move on to one of the most important distinct advantages that come with sovereignty and with statehood, namely the exercise of jurisdiction. In this first clip, I'll talk about the types and grounds of jurisdiction, before then moving on to discuss some of the limits of the exercise of jurisdiction, and that means that I'll discuss various types of immunities. Now, when we talk about jurisdiction, we talk about an expression of sovereignty, state sovereignty, that even if you didn't know the exact term, you have been familiar with from a very young age. Think, for example, of our perception of planet Earth. Next to me here, you will see a very famous photo taken from Apollo 17 in 1972. The photo is called The Blue Marble and is sometimes heralded as the beginning of the environmental movement. And what we see here is a mostly blue planet. You see some masses of land perhaps, but in general it is not at all obvious how this territory or how the surface is divided, if at all. Now, if I were to ask you to imagine the world, I think that some of you, perhaps even most of you, would get this image in front of their mental eye. And this, of course, is the world imagined according to international law, divided into separate, distinct spatial units, which we call states. And what drives this kind of division is, of course, on the one hand, the notion of state sovereignty, and on the other hand, the notion of jurisdiction, which makes it possible for us not just to imagine the world in this way, but also to just take it for granted and not question it when indeed we look at a map like this. The principle of jurisdiction is laid down in the UN Charter, and specifically in Article 2.7, which states that nothing contained in the present Charter shall authorize the United Nations to intervene in matters which are essentially within the domestic jurisdiction of any state. What counts as true for the United Nations is also true for other states. So once we know that something is within the jurisdiction of a state, and we'll get in a second to how we determine this, but once we know it, and once therefore it is not within the purview of international law, logically speaking, then it is really up to that state. It is the sovereign right of that state to decide what it does with its jurisdiction and how it seeks to exercise it. It is important to distinguish here between, on the one hand, the types of jurisdiction, and on the other hand, the grounds of jurisdiction. And Klabbers, in his textbook chapter, places a lot of attention in particular on the grounds of jurisdiction, what he calls the principles of jurisdiction. But I do think it's useful, even briefly, to discuss the types of jurisdiction, so the question of what a state effectively can do when it holds jurisdiction, starting of course with legislative or prescriptive jurisdiction, which means the power of a state to pass acts, legislative acts, through parliament that then governs the conduct of people, of legal subjects throughout its territory and sometimes even beyond. Quite a different type of jurisdiction is executive or enforcement jurisdiction, which is the authority mostly of the police, but also, for example, a prosecutor to enforce the laws of the land, so enforce those rules that parliament has passed. And finally, we have judicial or remedial jurisdiction, which pertains to courts and their jurisdiction to deliver judgments, render down judgments that are binding on questions of law, again, mostly, but not exclusively, only within the territory of the state. Having understood this, the question arises when a state can exercise its jurisdiction. And before we get to the specific grounds or principles, I do want to note that there is no obligation of a state to exercise its jurisdiction. So Parliament, for example, might decide not to use its prescriptive jurisdiction to pass legislation, or a prosecutor might decide not to exercise her or his executive jurisdiction. However, mostly states will be very protective of their jurisdiction and will exercise it quite assertively when given the opportunity. Now, there are 5 grounds of jurisdiction, and the textbook explains them in quite some detail, so I will not engage in an extensive repetition here. But I do want to say that the first one, the territorial principle, or in short, territoriality, is the most important one, by simple virtue of also being the most common one. So let me put a random number on this. 99% of all jurisdiction questions are actually answered with the territoriality principle, which means that effectively for most things, whether that's legislative or enforcement or judicial jurisdiction, For most cases, no question, no debate arises because we simply know that something happened on the territory and therefore the state has jurisdiction and can exercise jurisdiction in a particular case. The four other grounds of jurisdiction, and again I will refer you to the textbook chapter here for a more detailed description, are known also as extraterritorial jurisdiction. And this is so because these jurisdictional claims are made even though something did not happen on the territory of a state, but rather, for example, on the territory of another state or, for example, on the high seas. But regardless of this, a state still decides to make a jurisdictional claim, indeed based on one of these grounds. You can already deduce from this that there are instances in which there is concurrent jurisdiction, meaning that two or sometimes even more than two states all claim jurisdiction based on probably different principles. For example, some crime might have happened on the territory of one state but might concern the national of another state, meaning that both the territoriality and the nationality principle come into play. And it is indeed mostly in these kinds of criminal cases that these kinds of concurrent jurisdiction claims arise. So then occasionally in these criminal cases, the question arises which state should prosecute an individual. And there's been a strong incentive on states to collaborate on this question and to conclude what we know as extradition agreements. Extradition being understood here as a state's decision to recognize the jurisdictional claim of the other state and to give up and send the person, individual in question to that other state that is then able to exercise its executive and judicial jurisdictions. It is difficult to summarize the substantive content of these agreements because there are literally hundreds of extradition agreements, often in fact bilateral in nature, and providing different judicial and procedural guarantees that need to be fulfilled for an extradition to take place. For example, there's the double criminality principle, which suggests that an act needs to have been a crime in both states for an extradition to take place. So this double criminality principle is quite common in these extradition agreements. Now, safe to say there is a strong reciprocal element to these extradition agreements because states need to be quite confident that the other state will respect the agreement and will, in a procedurally reliable way, decide to give up and send the person if a request is made. To conclude, and just to repeat this once more, it is really important for you to distinguish between the types and the grounds of jurisdiction. And in fact, the grounds of jurisdiction, so having a legitimate claim based on one of these 5 grounds or principles, is the prerequisite for any type of jurisdiction to be exercised. This concludes this first clip. In the second one, I want to discuss one specific limit to the exercise of jurisdiction, and that is the question of immunities.